Good morning, everyone. It's a big pleasure to host you here today. I'm Alberto Gistinoi. I'm a partner at Cuatrecasas, and will be the host for the event today, where, as you know, we will be discussing on the most relevant topics connected with the digital package that the European Commission recently presented, and which legislative process has started. This is called to be a very significant legislative piece for the development of the digital markets at the European level, and we have thought that it would be great to put together not just a specialist, but also the different views from our different firms. Because as a matter of fact, this is an event which has been co-organized by our four law firms, which is Gleitz Lutz from Germany, Chiomenti from Italy, Cuatrecasas from Spain, and Gilles Loiret from France. So as I've told you, the idea is that where a specialist who is Mr. Dennis Sparas, who is a senior legal officer at DG Connect, will be making a presentation, firstly, on the content of the digital package. Then afterwards, we will be starting a round of questions. Firstly, those questions that you may pose through the Q&A that you have on your screen. And then afterwards, several partners from our firms will be also asking a round of questions to Mr. Sparas. So with the aim to be as quick as possible, I just open the floor to Mr. Sparas so that he can start with his presentation. Dennis, all yours.
Okay. Good morning to all. And first of all, thank you for the invitation and giving me the opportunity to present the digital services package. First, I hope you can all hear me well. And second, that you can also see the presentation. So if all that works, just as mentioned, I will do the brief introduction to the package, both the Digital Services Act and the Digital Markets Act, which were adopted end of last year, more correctly on 15th of December 2020, and which are essentially one of the key deliverables of the digital agenda strategy, which was presented by the Commission in March 2020. The presentation will probably take around 15-20 minutes, and really the idea is to have as much as possible the interactive discussion afterwards. So let me just try to see. So and let me hide this because it is, yeah. So very quickly, I mean, as we all know, since the 2000, when the current regulatory framework of the European Union, which is in the form of the e-commerce directive, has been adopted, we have seen the tremendous developments of the digital services in the European Union, but also worldwide. So, you know, services as such have developed. We have seen entry of many new market operators, which have not been known in 2000 when the framework was established. But what is also very important in the context of, you know, challenges that the regulatory framework is facing, or, you know, the legislators and the regulators are facing, is the fact that, you know, not only digital services are developing greatly and at the high speed, but also business models are developing very quickly and constantly. So, you know, even at the time when you do the let's say the assessment and the preparatory work for a legislative proposal, and by the time certain legal acts are adopted, you know, certain things may have moved forward quite significantly, and there may very quickly be a need, you know, to certain adjustments to the regulatory framework. So I mean, within this context, of course, you will all be aware of the calls for the Commission to look into this space and see whether the existing regulatory framework, in particular the e-commerce directive, which is a more horizontal framework, is still fit for purpose, and if not, what should be the next steps. And with this in mind, the Commission has launched just before summer 2020 so-called Inception Impact Assessment and the public consultation to provide the framework of preliminary analysis and the issues which the digital sector is facing, and raised number of questions as to how to address how best to address the challenges which have been identified. And it's important to keep in mind that those challenges are probably of the double nature. On one side, wider societal challenges which are related to availability of illegal but also harmful content online on one side, but then let's say narrower set of challenges which are more related to certain economic circumstances and market circumstances, where you have a small number of large market operators who are acting as gatekeepers in the market, and that may in itself raise certain issues. So the objectives that the new framework is essentially trying to fulfill and reach is, on one side, to create a safer digital space for users, but also not just like consumers, but also business users. And what is also very important, that the safer digital space ensures that fundamental rights of users of digital services are protected. And again, let's keep in mind that it's not only about fundamental rights of users as citizens or as consumers, but also fundamental rights of businesses. So, a typical one will be freedom to conduct business. So this is probably, not probably, but this is the objective, which is, let's say, of a wider societal nature, and where these objectives are being pursued through the proposal of the Digital Services Act. While on the other side, you have, as I already mentioned, a slightly narrower set of objectives, which is to establish a level playing field in the markets in the digital sector, to foster innovation, growth, and competitiveness, both in the single market as such, but also globally, as you will know from a number of let's say calls from policymakers like the member states and the European Parliament, but through also a number of studies and reports. And there was an increasing call and evidence of issues in this area, and the importance of adopting measures which would tackle different issues and problems identified. So when we talk about proposal of a Digital Services Act, the way let's say how best to describe the proposal in few words is essentially this is a new framework for providers of online intermediary services. And within that context, it's important to keep in mind that it's built on three pillars. One is the liability regime for providers of intermediary services, and as you have seen probably, this pillar is essentially built or taken from the e-commerce directive, because the evaluation of the e-commerce directive has shown that in as much as the directive is indeed from 2000, it's still very much fit for purpose. And there are certain challenges and issues which have to be addressed, but these are let's say add-ons to the issues which are already being regulated in the e-commerce directive. So as you have seen from the legislative technique, we have taken out from the e-commerce directive section 4, which is about the conditional liability exemption for intermediary services. We have put it in the Digital Services Act, because of course this is the part of the e-commerce directive which deals with the scope of the services which are in the Digital Services Act, but at the same time, the additional rules come on top of it. At the same time, the rest of the e-commerce directive, of course, very much still remains in force, and is the set of legal rules that will apply even after the adoption of the Digital Services Act. So this is one, let's say, pillar of the new framework. The second pillar is the proposal of asymmetric due diligence obligations, which I will touch upon a bit later on. And then the third pillar is, of course, the EU governance and enforcement, because one of the things we have seen from the e-commerce directive, that's very, let's say, e-commerce directive provided for a very basic framework of cooperation. But what has been shown through the experience in the last 20 years is that sometimes, or very often, it's very unclear how certain rules are enforced and by whom, and how to ensure cooperation, in particular in the cross-border context, so that the rules which are in place and which are fit for purpose, are properly enforced. I mean, again, you can have best set of substantive rules, but if the governance and enforcement lacks, the same level of ambition, very often those rules may remain, just rules as such, but not really ensure effective, achievement of the objectives which you're pursuing. So if we touch a little bit more on the first pillar, which I was talking about, which is the liability provisions. I mean, as already mentioned, the proposal of the Digital Services Act essentially maintains the principles of the e-commerce directive, but also builds upon them. So, there is still a possibility of the conditional liability exemptions. There is prohibition of general monitoring obligation, and just, as a matter of context, it's important to keep in mind that these are the principles which were very much, also endorsed by the co-legislators even before the proposal, both by the Council conclusions and the European Parliament report on the e-commerce directive. So it's very important to keep in mind. What is also very important to keep in mind, the DSA as such does not define what is illegal. So it doesn't really, it's not the set of rules which would define what is illegal in a given context. That's still to be done either by EU law or national law, which would be defining what in substance is illegal. What the DSA provides for is, the framework of the procedural framework, how to tackle, when such, illegal content or activity is available online, and how best to tackle it. Now, also what is very important, because, there were some calls that the Digital Services Act should deal not just with the illegal content as such, but also with the harmful content, is that, because of the nature of the harmful content, and because, the defining harmful content in a horizontal legislative act could be very, very challenging and, may raise a lot of legal uncertainty, it has been considered that it's important to focus on what is really, the most egregious, let's say, behavior which has to be tackled in the online environment, but at the same time, not to raise legal uncertainty. So most of the DSA provisions apply to illegal content as such. But of course, if you think about some of the due diligence obligations, when the very large online platforms would have to do the risk assessment, of course, in that context, some of these provisions would also be very relevant for harmful content, because, when they would be identifying the risk associated with the provision of their services, they would also be considering, not just the availability and dissemination of illegal content online, but also harmful content. As I already mentioned, the second pillar, which is the main novelty of the Digital Services Act compared to what we have in the current regulatory framework of the e-commerce directive, is so-called due diligence obligations. And you will see that the main idea behind the due diligence obligation is that those are of asymmetric nature, and these asymmetric obligations, are applicable based on the role of the intermediary services have in intermediating the content or activity online, their size, but also outreach in the society. I mean, you will all be very much aware of the fact that many, let's say, reports and studies define some of the services that fall within the scope of DSA as public spaces, and because of de facto, or in some ways sui generis, these being public spaces, it's also important that they are subject to more stringent obligations as compared to some intermediary services that are of limited reach, of limited size, and whose societal role may be much smaller. how we define the very large online platforms who are subject to essentially all the obligations which are identified in the Digital Services Act. We have set the value of at the 10% of the EU population, which was kind of considered as a proxy value for the significant systemic role of these services in the internal market and their potential impact on the wider societal ecosystem. Final thing that I would like to mention here is that the notion of very large online platforms should not be equalized with the notion of gatekeepers under the Digital Markets Act. As you will know, compared to the way we would identify very large online platforms under the Digital Services Act is very different to how we would identify and then designate the gatekeepers under the Digital Markets Act. You will be very well aware that there are number of additional criteria for identifying gatekeepers under the Digital Markets Act. And now, having talked about gatekeepers, it's kind of a nice introduction to the second part of the package, which is the Digital Markets Act, which is about very few large online platforms that have emerged in the digital sector, and which are essentially acting as gateways, both for business users and end users. And what is again important to keep in mind is, not that long time ago, the European Union has adopted the Platform to Business regulation, which essentially in a horizontal manner deals with the commercial relations between the platforms and businesses, and which is primarily trying to achieve, transparency in those relations and, transparency of the terms and conditions, in particular when it comes to, termination, suspension of the service, or certain conditions like, certain contractual conditions, like, for example, use of parity clauses. But that deals with, issues in this ecosystem in a horizontal manner, of the issues which are common to the whole, let's say, to the whole ecosystem. While what the Digital Markets Act tries to address is very specific problems which have been identified in relation to the behavior of, let's say, very few of these large online platforms that have a different role than all other platforms. As you will probably know, out of 10,000, let's say more or less online platforms that we have in the EU, only a very small percentage of those are, let's say, very, very large platforms, which may actually act as gatekeepers, and behavior of those may in certain circumstances undermine the effective functioning of the internal market. So what are the core principles of the DMA? It's a, let's say, ex ante regulatory tool. It's based on Article 114, so it's all about the harmonization of the rules of the member states' rules, and the objective is to ensure the contestability and fairness in markets where the gatekeepers are present. The main objective is to address the, let's say, the negative consequences arising from the behavior of some of these very large online platforms, which can be, in one way unfair, and in one way, it may undermine the contestability of the markets in the digital sector. As you will have seen from the proposal itself, we have identified gatekeepers as platforms with a significant impact on the internal market, which serve as an important gateway for business users to reach their, let's say, customers or consumers, and vice versa. And platforms which enjoy or are likely to enjoy in a foreseeable future an entrenched and durable position. You will see, these criteria identified in Article 3.1. What is also very important to keep in mind, that so only those large online platforms can be designated as gatekeepers which provide so-called core platform services. And those core platform services are identified in Article 2.2 of the DMA, and may contain services like online intermediation services, video sharing platforms, online search engines. We have identified 8 of those services. Gatekeepers can be designated in 2 ways. One is based on a rebuttable presumption, and the other one is based on a qualitative assessment following market investigation. I will not go too much into the details of this slide, but essentially, when it comes to designation through a rebuttable presumption, the DMA identifies certain quantitative thresholds, where it's assumed that, you know, if the provider of core platform services meets those thresholds, it essentially meets the requirements for being designated as a gatekeeper. But at the same time, it's a rebuttable presumption. So the presumed gatekeeper, let's say, can still come back and say, okay, it's true that, you know, I meet most of those criteria, but I consider that I don't, so that I meet most of those thresholds, but I still consider that I don't meet the criteria, and these are the reasons why not. On the procedural side, there is a notification obligation on the side of the providers of core platform services, and the obligation of the Commission to designate the gatekeeper within 60 days, unless, of course, the rebuttal is presented, where then the Commission would need to move to the market investigation stage. But at the same time, it's also important to keep in mind that there is a slightly different way of, you know, designating through a market investigation when it comes to rebuttal of the quantitative presumption as compared to a normal qualitative assessment, where in particular the level of the assessment and, you know, the market analysis would be slightly different, because in case you are meeting quantitative thresholds, it would normally be only in exceptional circumstances, you know, that you would probably be able to show that you are not a gatekeeper. Then, once designated as a gatekeeper, the idea of the Digital Markets Act is that you have to comply with the list of defined obligations, which are defined primarily in Articles 5 and 6, but there are also some additional ones which are more about the notification and transparency measures in Articles 12 and 13. The main difference between the obligations in Article 5 and 6 is that, you know, while they are both directly applicable, which means, you know, there is no question if somebody has to comply with it, but, you know, more a question of how. The question of how does not really arise in relation to obligations in Article 5. So essentially, they are directly executable, let's say, because it's very clear from the way that the obligations are defined what the designated gatekeeper has to do. While in certain circumstances for the obligations under Article 6, it may be that there is a question whether the measures which the designated gatekeeper intends to put in place to comply with those obligations really achieve the objectives pursued. So there may be a regulatory dialogue between the Commission and the designated gatekeeper to ensure that indeed the measures which are being put in place are ensuring effective compliance with those obligations. Important to keep in mind, obligations apply to core platform services that meet the conditions of gatekeeper. So while one would designate as a gatekeeper the undertaking, you know, it would still, under Article 3.7 of the DMA, the Commission would still need to identify those core platform services that would need to, you know, comply with the obligations laid down in Article 3, in Articles 5 and 6. There are narrow exemptions to the compliance with the obligations, which are defined in Articles 8 and 9. So, like exemptions in case of, you know, certain public interest, or, you know, in case the compliance with the obligations would endanger the economic viability of the gatekeeper as a company. And then maybe last important point when it comes to obligation is that certain of those obligations, so obligations as such would apply to the gatekeeper. All the obligations would apply to the gatekeeper, but in certain circumstances, which is, you know, so-called emerging gatekeeper, you know, not all of the obligations would apply, but also only those obligations that in one way or another can undermine the contestability of the market and, you know, may lead, if not complied with, to the tipping of the market in favor of the emerging gatekeeper. Just very quickly on some of the examples. So we have, I tried to put here in some groups, you know, so you have like data related unfair practices where, you know, you can see obligations like ban on the use of non-publicly available commercial sensitive data of business users, or obligation on the gatekeeper to provide effective portability of data, which would apply both to end users and business users. Then let's say a set of obligations concerning unfair favored treatment, which would be, obligation to allow business users to promote their offers to their customers, outside the gatekeepers' platforms or services. Then, obligations concerning unfair access conditions, such as like ensure fair and non-discriminatory conditions of access. And then, certain obligations concerning the unfair advertising related practices, primarily in relation to transparency, but also, around the price paid by the advertisers or price paid to the publisher, but then also, ability of the publishers and advertisers to see how effective certain advertising campaign has been. So obligation to provide access to certain measurement tools of the gatekeeper. And then finally, on the governance structure, I mean, just very quickly, it's slightly different between, well, it's quite different between the Digital Services Act and Digital Markets Act. On the side of the Digital Services Act, the main enforcement structure is, of course, the digital services coordinators, which are independent authorities in the member states, which would be primarily responsible for the enforcement of the Digital Services Act, which is very much in line with the country of origin principles, which, we have seen that the e-commerce directive was built on, and the Digital Services Act, puts it at its core. So it's all about the fact that, the providers of intermediary services are regulated in the place where they are established, which of course doesn't mean that in certain circumstances there may not be a cooperation between digital services coordinators of the country of establishment and country of destination, or even other competent authorities, because as you will see, the Digital Services Act is a horizontal tool. So of course, the areas that are covered may, touch upon areas of competence of many other authorities, and therefore, the question always arises, what is the relationship between the digital services coordinators as independent authorities enforcing the Digital Services Act, and other competent authorities responsible for enforcing other rules in this ecosystem. The Digital Services Act also envisaged establishment of so-called European Board for Digital Services, which is essentially a group of the independent digital service coordinators, whose role is primarily advisory one, and where they can recommend certain actions both to the digital services coordinators, but also to the European Commission. And then the role for the European Commission, which is primarily related to oversight of the whole system, and also very direct role in the enhanced enforcement of the rules in relation to very large online platforms. So that's when it comes to Digital Services Act. On the Digital Markets Act, the governance structure and the enforcement structure is slightly less complex. So the primary enforcer of the rules is the European Commission, who would be responsible for designating and enforcing the rules, and also ensuring that the rules are being complied with. And then there is a strong role for member states through the Digital Markets Advisory Committee, who would be advising both on the individual decisions of the Commission, but then also certain implementing acts or delegated acts in line with the existing interinstitutional governance rules that we have in place in the European Union. So I would stop here. I think I already took quite a bit of time, and looking forward to our discussion.
Thank you very much. Thank you for the for the presentation. We as I've mentioned to you before, we have received several questions from the audience. So maybe what we can do is that I pose those questions to you, and then we can afterwards open the floor to the partners from the firms to ask you their own questions, right? So the first question that we have selected relates, as a matter of fact, we have selected 5 questions, 3 of them being related to the Digital Services Act and 2 of them to the Digital Markets Act. So the first one relates is referred to how will the Digital Services Act impact on the acquis of the directive on copyright in the digital single market. particularly concerning orders to act against illegal contents as defined in Article 8 of the DSA, as well as two elements to be mandatorily contained in the notices under Article 14 of the DSA, so including the obligation to indicate the URLs of the illegal contents to enable the identification thereof. So how will both pieces of legislation be made compatible?
I mean, I think this question is valid not just for the relationship between the DSA and the Copyright Directive, but also other pieces of EU legislation. You know, I can imagine Audiovisual Media Services Directive, you know, or legislation in area of criminal or civil justice. So, I mean, essentially, the idea is that the DSA is without prejudice to any of these rules. So, to the extent that these rules provide for specific provisions and specific requirements in relation to any of the issue which is being let's say regulated by the Digital Services Act, of course those specific rules, so let's say lex specialis, would prevail. But to the extent, of course, that those specific rules do not legislate a specific question, of course the horizontal rules would apply. And that would also be the case where, for example, the EU law and the relationship between DSA and that piece of EU law leaves member states certain discretion when it comes to regulation of a specific question or a specific area. In that case, that discretion would be essentially legislated on by the Digital Services Act, who would be providing for harmonizing unified rules in that area. But just, I mean, what I would like to reassure everybody, and I think, not just me, but we are always, in all our interventions saying that, I mean, the idea of the DSA is not to open and duplicate and replicate the discussions which were held when the other pieces of EU legislation were adopted. And, in particular, this question often arises in a relationship between the Digital Services Act and the Copyright Directive. And indeed, we can confirm there is no idea to reopen the discussion which has been finalized in the context of the Copyright Directive and provide for specific rules in the DSA. I mean, of course, specific rules in the DSA are relevant where, let's say, the Copyright Directive says nothing about the specific issue. So yeah, that's the idea. And again, the idea of the without prejudice clause in Article 1.5 applies not just to the Copyright Directive, but also to other pieces of EU legislation, which may be dealing with specific aspects of the issues that are dealt with by the Digital Services Act. And again, Copyright Directive, Audiovisual Media Services Directive, Terrorist Content Online Regulation, e-evidence proposal, which is still a proposal, but once adopted, would have specific rules for some of the issues which are being tackled in the Digital Services Act. So, I mean, set of rules which provide for specific solutions. And from the legislative technique point of view, I mean, this is relatively normal that, the act that comes later essentially defines the relationship to other pieces of EU legislation, which I hope replies to the question.
Yeah, absolutely. Thank you very much. So the second question reads like this. So the DSA has kept the categories of intermediaries defined in the directive of 2020. So mere carrier, cache, and hosting operators, without clarifying where relevant players like search engines or cloud hosting service providers should be considered to fit in. So could you provide your thoughts on the qualification that such type of operators, so again, search engines or cloud hosting service providers, should be considering to fall in within the logics of the DSA?
Yeah, so I mean, indeed, what the DSA did, it simply, as I already mentioned during my presentation, let's say took over, replicated what is in the e-commerce directive when it comes to defining the scope, right? Because as I already mentioned, contrary to e-commerce directive, which deals with information society services, The Digital Services Act, the scope of it is dealing with the narrower scope of those information society services, which is intermediary services. But there is a part of e-commerce directive which deals with intermediary services, which is exactly the part on conditional liability exemption in the e-commerce directive. So the idea was to define the scope along the lines of the e-commerce directive, because it was considered that that's still relatively well, that's still valid for the purpose we are dealing with here, but at the same time trying to provide certain clarifications, right? So the question here, I guess, goes more into the direction, within which of these three categories, I don't know, online search engines or cloud services could fall in. And indeed, what the Digital Services Act is saying, it will very much depend on the individual circumstances and case-by-case assessment. But what the Digital Services Act tries to say and provide the clarity is, indeed, there are certain new services which were not considered at the time of the adoption of the e-commerce directive, which would fall within the scope, but it cannot be set a priori within which of these three intermediary services. So, for example, in recital 27 of the proposal, you will find different services like domain name systems, like top-level domain name registers, also web-based email services. I mean, again, we try to provide certain examples of new services which have developed in the meantime, but without saying within which of the categories would fall, because it will very much depend on how the service is provided and what kind of service are we actually talking about. So, like for online search engines and for cloud computing services, it will again very much depend, on the characteristics of the service. I mean, you will see from the national case laws, but also, from the EU law, that in certain circumstances, let's say online search engine could be considered as a hosting service. But, you also see from many input to the public consultation that, this is a service which should be considered as a caching service, because it doesn't really fulfill the conditions of the hosting service. So it will very much depend on the individual assessment against the conditions which are set in the DSA. I think this is an issue which is also coming, I mean, to be very transparent, as you will probably know, that's coming very high in the discussions, both in case of both co-legislators, so in the Council and in the European Parliament. So at the moment, there is a reflection, whether further clarifications in one way or another could be provided in the DSA as finally adopted. But I mean, we are at the early stage of reflection on that. But of course, it's a very important question and very valid question. And it would seem, that both co-legislators would want to provide an additional clarity without necessarily going into the direction to say, per definition, online search engine service will always be a hosting service, or per definition, it will always be a caching service, but maybe provide certain additional clarity to what already exists in the proposal.
Okay, great. Thank you. So last question from the attendants on the DSA. It's like this. So how will the provisions under the DSA impact on the principles laid down by the European Court of Justice in the judgment, in the recent judgment, as you know, in the joint case related to YouTube and Ciando, so cases C682/18 and C683/18, and particularly including as regards of the standards of knowledge of the illicit nature of the content by the hosting service provider.
Yeah, I mean, I know why I didn't, I forgot to say something in reply to the previous question, but this question is perfect to follow up on that. One of the reasons why we also felt that, to the extent it's not really necessary, and this has not been shown through the impact assessment analysis, to change anything in relation to the, let's say, conditional liability exemption regime, which we had in the e-commerce directive, we consider we should not change anything. So, you will have seen that Articles 3, 4, and 5 of the DSA proposal essentially, let's say, by word replicate what is in Articles 12, 13, and 14 of the e-commerce directive, with the exception of Article 5.3 of the proposals. And the idea here was that, you know, we should keep as much as possible the existing rules, which are still fit for purpose, as shown by the evaluation of the e-commerce directive, in order also to benefit from a relatively rich case law that we already have in this area, right? I mean, it's not only about the recent YouTube case, which in our view very much confirms the existing case law when it comes to different aspects, for example, of the provision of the hosting services, but it's, you know, about, you know, many other things which are very relevant for the interpretation of these provisions. You know, you will have, you know, case like McFadden, you know, where it was very clearly established that Wi-Fi services, you know, would also be part of the scope of the intermediary services in the e-commerce directive, or, you know, you have certain rules established by the Court of Justice when it comes to, you know, what are the criteria to establish the actual knowledge, for example, through the notice by the user. So we felt that, you know, because there is already a very useful and, you know, rich case law on several of the aspects of the provisions, which, you know, are still considered very much fit for purpose, that we shouldn't change anything. And, you know, from our perspective, the recent YouTube case essentially more or less confirms the existing principles on which the DSA is largely built on, but provides certain additional clarifications. For example, I think the YouTube case may be very relevant, you know, when it comes to the notion of actual knowledge through the voluntary measures, you know, and you know, so there's certain, let's say, additional clarifications provided by the YouTube case, which can be useful for the implementation and enforcement of the rules. But essentially, it confirms the basic principles, which are also the basic principle which are underlying the proposal.
Great, thank you. So now tackling on the DMA, first question is, what would persuade the European Commission that the companies targeted by this proposal have different business model, and so the DMA obligations should more accurately address the type of company?
Yeah, I mean, I guess the question here is, you know, indeed we are talking about 18 obligations in Articles 5 and 6, and many of these obligations will apply essentially to any of the 8 core platform services that may be designated as a gatekeeper services, right? And you will see from the way the obligations are defined in Articles 5 and 6 that it's not that all of these obligations apply to all core platform services. You will see that some of these obligations are already defined in a narrower scope, because it has been considered, for example, that they are not relevant in all circumstances or in relation to all core platform services. And where this has been considered to be the case, you know, we have clearly defined that already in the.
Sorry, I lost my connection for a second. Sorry for that. So finally, what consideration did the European Commission give to private enforcement of the DMA in its proposal? So what do you think is the right model for enforcement as between private parties, NCAs, and the European Commission?
Yeah, when it comes to private enforcement, it's a very interesting and very valid question. I mean, we felt that, you know, since, you know, DMA is a regulation, so it's directly applicable and enforceable rules, you know, based on the existing principles of EU law, nothing prevents, you know, private parties to go to the national courts, and, you know, to the extent that they fulfill the conditions under which, you know, they can argue the direct applicability and, you know, sue in front of the national courts, they can do so. So we felt at the time when we were, you know, putting forward the proposal that there is no specific need to lay down that specifically in the proposal itself. But the question comes back, you know, from both co-legislators who are asking whether this is possible and under which conditions. So, you know, there is a reflection ongoing whether, you know, as part of the, let's say, you know, the co-legislation process, you know, there may be there may be a need for clarification of this, but from our perspective and our understanding, it has always been the case that, you know, we consider that the DMA rules could be privately enforced by the parties, I mean, by the, let's say, potential beneficiaries in front of the national court. So it has never been considered that this is not possible. Again, you know, we are talking about directly applicable regulation, directly applicable rules, which are, you know, defined as clearly as possible, in particular, as I was already mentioning, in relation to obligations under Article 5 of the DMA. So indeed, you know, our understanding and our approach has always been that private enforcement is possible. But again, it's a very valid question. It's not necessarily super clear from the proposal itself. And, you know, it is a question which is coming back from both co-legislators, and where, you know, maybe quite likely, you know, certain clarifications will be provided in the final act.
Perfect. So thank you very much. I think that now we can start the round of questions from the partners of the four firms organizing the event today. So maybe we can start with Stefan Weider. He's a partner from Gleis Lutz at the Berlin office. So Stefan, if you want to go on.
Thank you, Albert. Thank you, Mr. Sparas, for sharing your special knowledge and for your very clear and interesting presentation and answers. My question relates to the notice and action system, and I assume I already know your answer, but the DSA proposes in Article 14 for a notice and action system for host providers. What about notice and stay down? Is this also required as indicated by the ECJ in its Glavischnik decision, and will automated filters or upload filters not only be allowed, but even required?
Okay, so first, what I want to clarify is that indeed Article 14 obligation is essentially obligation on providers of hosting services to put in place an effective notice and action system. So essentially enable users of their services to be able to notify to the provider that, you know, they have come across certain illegal content and requiring certain action on the side of the service provider. Nothing in the DSA or Article 14 requires so-called notice and stay down, you know, so it doesn't go in direction of saying like, okay, once the notice has been given and once the content has been removed because it has been considered illegal, the service provider would also be under an obligation to ensure that the same type of content does not reappear, same or similar type of content does not reappear in the future. So there is nothing in the DSA like that. And the main reason for this is, you know, the relationship between so-called stay down obligations and the prohibition of general monitoring obligation. And when you were referring to the Glavischnik case, I mean, essentially what the Glavischnik case in our understanding and the way we see it, you know, says is, you know, in certain specific circumstances, you know, the competent authority may require a service provider to take measures to ensure that illegal content, which has been, you know, previously identified as such, does not reappear. But the very important point there is, you know, in specific context for specific type of information. So not like a general, let's say, stay down obligation where, you know, somebody would need to be monitoring everything and, you know, trying to identify whether illegal content previously identified would need to be removed or access to it disabled. And what is very important, this principle has been again reaffirmed in the YouTube case, you know, so the court again says, you know, I mean, the service provider is not under a general obligation, you know, to monitor everything and, you know, to remove content, you know, that may have been, you know, previously identified as illegal. So, I mean, just to confirm, there is no stay down obligation. This is a very sensitive, you know, you will know from the previous discussions in some other areas like copyright, this is a very sensitive issue in particular, because there is still a general principle of, you know, prohibition of general monitoring obligation, which is at the core of the rules. And, you know, that therefore, you know, based on the criteria in Glavischnik case, of course, competent authorities of member states, in particular, judicial authorities, when they're issuing certain orders, would have to, could require such an obligation in specific circumstances, but of course, under very narrow conditions defined in Glavishnik, not in a very general manner. And, just to make a parallel maybe to copyright directive, even there we are talking about the best endeavor, best effort attempts in a very specific area. So we are not talking about the horizontal set of rules, right? We are talking about lex specialis, which applies to specific area of law. And as regards automated upload filters to be allowed or even required, I mean, automated upload filters are being used by the service providers as part of their voluntary measures to see what is happening on their service, and it's not something that is necessarily prohibited, and I mean it's happening. But one thing again for sure, they are not required by anything in the DSA.
Okay, well, thank you very much. So next one to ask is going to be Thierry Dor. He's a partner at Gilles Loiret in the office of Paris. So Thierry.
Thank you, Albert. Mr. Sparas, you've clearly explained that there are additional criteria to distinguish between the gatekeeper and the very large online platforms. What was the rationale for not trying to create a connection or links between the two concepts? And also, a question you've certainly received is, why did you prepare two texts and not one? Because the idea is one framework, and the two texts are creating a certain complexity.
Yeah, okay. So as regards one or two texts, I mean, as I already said, the type of issues which we are trying to tackle through different set of rules are very, very different. And that was also one of that was the main reason why, for example, we are dealing with the rules for providers of intermediary services, which is kind of a subset of what we have in the e-commerce directive in the Digital Services Act. And then, more, let's say, very specific issues when it comes to fairness and contestability of platform ecosystem and, markets in the digital sector as part of the Digital Markets Act. And because the two sets of issues are very, very different, it has been felt that, yes, indeed, they apply to the digital sector, let's say, or to the online platform, but not only, right? So it has been felt that these rules have to be in two separate acts. Of course, there is a third, let's say, set of rules which has been considered at the time, so as you will know very well, so at the time of public consultation and the inception impact assessments, when it comes to Digital Markets Act, there were two separate public consultations. One was, on so-called ex-ante rules on gatekeepers, and the other one was new competition tool. And there, indeed, it has been felt that, since those, let's say, those two potential initiatives are tackling a very similar type of issues, where the main issues which have been identified are in relation to the digital sector, it has been felt that, one should not come with two proposals, but rather with one, and tackle the main issues, which are, all the issues about the fairness and contestability in the digital environment. As regards the relationship and the notions of very large online platforms and, gatekeepers, again, the objectives and the problems which have been identified are very, very different. I mean, as I already mentioned, the DSA tries to tackle a wider societal issues. Objectives are slightly wider. We are trying to tackle, availability and dissemination of illegal content online. And, we want to ensure that, users are protected online while, the sector as such can still strive and grow. So, we are tackling specific set of issues, while in the case of gatekeepers, we try to identify probably a subset of, a very large online platform, which also act as gatekeepers, right? And gatekeeper, I mean, not all very large online platforms will necessarily act as gatekeepers. I mean, again, this is not to say that, all gatekeepers will necessarily also be very large online platforms, but it is quite likely. But again, we are pursuing two very different objectives, and when we talk about gatekeepers and when we talk about issues which we are trying to tackle with the Digital Markets Act is a let's say subset of problems, which is more of economic nature and not a wider societal nature. And that was also one of the reasons why it has been felt that, you know, these two set of rules have to be separate. And again, you will have other set of rules which will be very relevant for the digital environment and which are in specific acts and not in a, let's say, a big code which would deal with everything when it comes to digital platforms. Because then the question could also be, you know, should we include also rules like platform to business within that one set of rules which would apply to digital platforms?
Great. So thank you very much. So next question will be posed by my fellow partner from Cuatrecasas from the Madrid office, Álvaro Burkay. So Álvaro.
Thank you very much, and thank you very much, Mr. Sparas, once again for your presentation, for spending the time with this already highly populated group. My question is around the country of origin principle on the DSA, which I believe is one of the cornerstones of the digital single market. And I'm pretty sure the Commission agrees to that, because on the consultation on the Digital Services Act, it says that it ensures that digital innovators, including startups and SMEs, have one set of rules to follow, that's of their home country, rather than 27 different rules. And it goes on saying that this is an important precondition for services to be able to scale up quickly and offer their services across borders. However, practice has proven that member states have an inclination, have a tend to impose varying obligations on notifying, detecting, and removing content, and that may lead to fragmentation of the internal market. On the services side, it imposes regulatory complexity, and it makes even unworkable compliance systems. And on the user side, it's difficult to understand how 27 different approaches may lead to 27 different results on the very same content. So I guess my question is, how is the country of origin principle addressed on the DSA, and how does it interact with other regulations to avoid it, slipping through the cracks? Should the draft be reinforced on that end?
So I think when it comes to the description of the problem, I think, you're spot on. It's like you could probably help us drafting the impact assessment analysis. But that's exactly what the idea of the DSA is. I mean, you will see from the whole concept and structure of the Digital Services Act, it is based solely on the country of origin principle. There are no exceptions to the country of origin principle in the Digital Services Act, or even possibility of such an exception, which is something which is still tackled under the e-commerce directive, in particular Article 3, which remains fully applicable. So when it comes to the obligations which are laid down in the Digital Services Act, it's very clear from the proposal that compliance with those obligations has to be ensured in the country of establishment of the service provider, and there are no exceptions to that. So in sense, one of the reasons for this was exactly what you were describing too, that what we see across the EU, across the internal market, is increased number of national rules which lead to fragmentation in different areas which are being dealt with in the context of the DSA, and which provides for a regulatory complexity, of course, for SMEs who may want to grow beyond their national, let's say, markets, or beyond, the place where they are established, but also for, very large online platforms, where we still want to ensure that those platforms, even if they should be subject to increased set of due diligence obligations because of their societal role. I mean, they should still be able to benefit from harmonized set of rules across the EU and provide services seemingly, which will then also benefit the users because they will be able to access those services seemingly. So from that perspective, DSA is solely based on the country of origin principle. Now, the only, let's say, clarifications to some extent, we provide in the DSA are Articles 8 and 9, where in case of specific item of illegal content or specific request for information, also country of destination can ask those, can ask the removal, or let's say, of the illegal content through the order, or can ask for a specific set of information. Let's say in the tourism sector, you will have many cities that may be interested in information which the platform facilitating short-term rentals may have access to. So in that cases, that is also allowed for the country of destination. But this is already the possibility today. What we wanted to provide with Articles 8 and 9 is essentially legal certainty for both the authorities, but also for the service providers, to know that when they are subject to such requests, they would essentially need to comply with them to the extent these requests fulfill the requirements in the DSA. But at the same time, also clarifying that such type of requests, if they are in relation to specific item of illegal content or specific item of information, do not represent restriction of free movement of services within the meaning of Article 3 of the e-commerce directive. Of course, member states who may want to regulate, they would still be subject to Article 3 requirements of the e-commerce directive. And of course, to the extent that they are adopting general rules of general rules in the area of information society services, they would need to notify those type of rules under the transparency directive. And there, there is a specific procedure in place for the Commission to assess compliance with the of those national rules with the existing EU law. And of course, once the DSA will be adopted, this will provide for an important element of that assessment. So to the extent that member states would want to regulate in the area covered by the DSA, of course, they would be precluded from doing so.
Thank you very much.
Right. Yeah, thank you very much. So the next question will be posed by Giulio Becchi from Chiomenti, from the Milan office. So Giulio.
Thank you, Albert, and good morning, Mrs. Sparas, and thank you very much for your availability this morning. And going back to the liability regime, basically the Digital Services Act, in the Digital Services Act, which is the point of balance between the possibility for hosting service providers to benefit from the safe harbor regime and the possibility to make autonomous investigation in order to basically monitor whether unlawful activity has been carried out through the platform. In particular, when such investigation is conducted on a regular basis. I think that this is a very important point because can be able to distinguish from the hosting service from an editorial activity, a pure editorial activity. So I would, it would be interesting to know your view on this.
Yeah, I mean, you're raising a very valid question, and this is a point which has come back a lot in the public consultation, but already before, right? Because on one side, it's very clear that, let's say, there is a societal expectation that the in particular, very large online platforms also fulfill their social responsibility, and ensure that the provision of their services is conducted in a way that is safe for the users online, right? And part of that, let's say, socially responsible behavior is also, for them ensuring that their services are not used or misused, let's say, maybe better word, for dissemination of illegal content or for any type of illegal activity. And many of these providers, of course, have means and measures that they could employ or are employing, where they are proactively identifying whether there is something illegal actually taking place. But there was a big question mark when it comes to these type of voluntary measures, in particular in relation to what you were referring to. What is the relationship between these voluntary measures, which could lead to the actual knowledge about the illegal activity, because that's also something which the case law confirms, and the fact that, you know, the service providers want to and, you know, would like to benefit from the conditional liability exemption regime, in particular when it comes to, you know, hosting services. So here, what is very important to keep in mind is the DSA proposal simply tries to provide the legal certainty for the service providers, tries to say, you know, the mere fact that you employ own initiative voluntary measures to detect and even remove content that may be illegal or content that may be against your terms and conditions, that mere fact does not lead to the actual knowledge. One would still need to prove that, you know, even after own initiative voluntary measures, they identify certain content, they didn't take any measures, but, you know, the own initiative voluntary measures have led to the actual knowledge. But that would have to be assessed on a case-by-case basis. You know, what the DSA simply tries to clarify is the mere fact that they are doing so does not lead to the actual knowledge. And this is also, again, one of the points which comes across also a little bit in the YouTube judgment, recent YouTube judgment. You know, that, you know, the mere fact that you know, somebody employs certain techniques to identify illegal nature of certain content does not lead to the actual knowledge. So in that sense, we continue to feel that, you know, Article 6 is an important clarification, an important element of providing the legal certainty, but at the same time, you know, in no way changes the existing regime where the service provider, upon obtaining the actual knowledge, which can also be through voluntary measures, let's be clear, you know, would need to take action in order to benefit from a liability regime. So in that sense, we feel that, you know, the two are very much consistent, but at the same time, there is an added value in Article 6 in sense of providing legal certainty and clarity on the issue, which has been raised by many stakeholders in the past, in particular, saying that, you know, there is disincentive in the existing framework because of the legal uncertainty. Service providers are not willing to employ these own initiative voluntary measures and kind of behave in a socially responsible way.
Great. So we starting the last round of questions now, and I pass on the floor to Moritz Holm-Hadula from Glaser Lutz, Stuttgart. So Moritz, all yours.
Thank you very much, and thanks also from my side for the great presentation. I'm an antitrust lawyer, so naturally I'm interested, and my question is related to the DMA, and is in the broader context of the list of gatekeeper obligations that you have been elaborating before, and more specifically, the question relates to Article 10, so the power of the European Commission to kind of update the obligations, the gatekeeper obligations. And I appreciate that this power is subject to a prior market investigation, and there's also a general framework kind of defining the situations in which the European Commission may update those obligations. But I guess my question is how you expect this to pan out in practice, and more specifically, whether in case of, let's say, more far-reaching amendments to the gatekeeper obligations, whether you think it's necessary to run through the legislative process instead of kind of equipping the enforcement agency as which the European Commission acts in these cases, to equip this enforcement agency with quasi-legislative powers to kind of update its own the own provisions that it is applying, quote unquote, on the fly. So that would be very interesting for me to hear how you expect this to play out, really.
Yeah, thank you for the question. I think again, it's a very interesting question, and as you said, you know, it is something which is not only about it's not only about the DMA as such, but it's also about let's say the general framework of adoption of delegated acts by the Commission. The powers of adoption of the delegated acts by the Commission, and the idea here is, coming back to your question, what if there would be more fundamental changes to the obligations in Articles 5 and 6? And I guess when you mean by fundamental changes, you may mean completely new obligations, or really completely changing the scope of the obligations which are in 5 and 6. And I think I would like to, I'm sure you know that, but I would like to refer you to Article 17, where essentially the idea of the market investigation and the possible outcome of the market investigation in terms of the further updates to the obligations is twofold. On one side is, the Commission may adopt a delegated act to amend the to supplement or amend the obligations in Article 5 and 6, but only to the extent, that those amendments are somehow pursuing the same, let's say, legal test which has been used to identify the existing obligations. And that legal test is defined in Article 10.2, which is about the fairness and contestability. So to the extent that new unfair practices or new practices undermining contestability would need to lead to amendments of some of these obligations, that would somehow be within the scope of the empowerment. But if we are talking about, if the market investigation would show that there is a need of a completely new obligation or completely different obligation, that would probably mean a fundamental change to the DMA, which cannot be done through the delegated acts and through the empowerment which has been given to the Commission, but rather through the new legislative proposal as part of the review of the Digital Markets Act as such. And again, this is the differentiation which we try to capture in Article 17, already trying to say, okay, there are two possible scenarios, and they will very much depend on what is the outcome of the market investigation. And finally, just very briefly, this is an issue which is, of course, of important interest also to the both co-legislators, and there are ongoing discussions, whether certain additional clarifications and safeguards would be required, in particular in the context of Article 10, to circumscribe the empowerment for the Commission even more clearly. So it's not excluded that Article 10 in the final form may look a bit different in sense of, being even more concrete in which scenarios and which circumstances the Commission may supplement or amend the obligations under Article 5 and 6. But you are perfectly right, the framework within which we are moving is the framework of general rules which are laid down in Article 290 of the treaty, and everything related to it, including the case law.
Thank you.
Thank you very much. So back to Thierry from Gilles Loiret, Thierry Dor.
Mr. Sparas, Article 2 of the DSA gives the definition of advertisements and recommender system, but the scope of the two definitions is not always crystal clear, and the distinction neither, as there is potential overlap between the two concepts. So do you expect some more specification regarding those two concepts during the legislative process, and do you have any specific comment in that respect?
Okay, so I have to admit that so far I haven't seen that many amendments, in particular through the reports by the responsible committees in the European Parliament on these two definitions. I think the question has been raised already in sense of what is the differentiation between the two, and it is important to keep in mind that when it comes to the recommender system, which is essentially about suggestions given by the user of the specific service, what information is presented to it. It has to, it's important to keep in mind that, those recommendations, so the recommender system may not simply work on the advertising side, so it may not come simply from the perspective of specific content that is being shown to you based on the based on the advertisement related issues, but it may simply be about our general behavior online and tracking of the user through the behavior online. So in that sense, recommender system can go much broader than the what type of advertisement is being shown to us. So from our perspective, we do see a slight nuance and the differentiation, and therefore you will see that the transparency measures which are envisaged for the advertising related issues in Articles 13, 23, and 33 are specifically about the transparency measures on the advertising behavior of the providers of intermediate services, while Article 29 is more specifically about the transparency in relation to the use of recommender system and how certain issues are being shown to the user. So we see the difference. I don't think that as anything in the proposal, it may change in the co-legislative process, but let's say this was not, at least as to my best knowledge, I'm not excluding, I may be missing something, a big question mark from either side of the co-legislators at this point, but the question has been raised for sure.
Great, so thank you. Next question will be posed by Joanna Mota from Cuatrecasas from the Lisbon office. So Joanna, all yours.
Okay, thank you very much, Albert, and thank you, Mrs. Sparas, for your great presentation. Well, my question is related with the startups ecosystem. This because on the massive response to the public consultation, one of the things that has been severely tackled by small, medium enterprises and startups, they say these obligations are completely focused on big companies, on larger platforms, and they feel some way that it can be the rules and the one-size-fits-all rule can be completely disproportionate and can even jeopardize their growth, their evolution. Do you think the package itself covers these concerns? Do you think they are completely well-balanced rules? What is your opinion about this?
I mean, from our perspective, that was an important driving principles when we were, working on both legislative proposals. And again, when it comes to the Digital Markets Act, when I was trying to make a differentiation between the platform to business regulation as a horizontal set of rules as compared to DMA, it's quite clear that, with the DMA, we are trying to tackle a specific set of issues which is about the behavior of very large online platforms, that act as gatekeepers, So in that sense, it is already clear from the identification of the problem and the issue which we are trying to tackle is that, problem concerns only very limited number of market operators. So in that sense, obligations deriving from the DMA will be asymmetric by nature. And of course, one of the main objectives there is, to facilitate innovation potential and, the growth of the SMEs across the internal market, also by benefiting through the obligations which are imposed on gatekeepers. So in that sense, we are very confident that the DMA, very clearly delivers on that objective. I would argue, the same for the DSA, which again, through the asymmetric set of obligations, tries to clearly establish, the different obligations depending again on the size, nature, and the reach of the activities. And, again, the driving principle there was we should not be imposing, disproportionate obligations on the smaller providers of certain services. But at the same time, we should also not simply exclude them, So you will see that for some of the provisions, we have certain exceptions for small and micro enterprises. But, at the same time, there are some basic requirements where we felt that, all service providers would have to comply with. And, these are very basic ones, having a contact point, having a legal representative where this is necessary because you're third country service providers, on having some basic transparency requirements. This is something which I think, irrespective of your size, you should be providing to your users. But then at the same time, when it comes to risk assessment, if you are a small micro company, I mean, it makes no sense that you would be doing this type of thing. So yes, we really firmly believe, and this is also coming from the both impact assessments, that both proposals are very well balanced and do not impose disproportionate burdens.
Okay, thank you very much.
Great. So the final question will be asked by Gilberto Nava Chiamendi, from Milan. So Gilberto.
Thanks, Albert. Thanks, Mr. Sparas. Thanks for your presentation, and furthermore, thanks for your availability for discussion, which is very important for us. My point is focused on the question of impact of European regulation on the relevant markets. This point has already been mentioned in your presentation, but I would like to focus a bit furthermore. The platform to business regulation, which has been issued in 2019, as we know, which the DMA is expressly partially built on, already introduced a number of obligations with the goal of pursuing transparency and fair contractual relationship between online platform and business users. Why the Commission at the end of 2020 deemed necessary to further intervene with the ex-ante asymmetric obligation, while some member states, like, let me say, Italy, are still moving their first step to start enforcement of the platform to business regulation, and the related effects on the markets involved are still unknown and probably will be unknown for months or for years. Thanks.
Thank you. Again, I think a very valid question, and question which we try to address through the analysis which we have done in the impact assessment. And indeed, as I was already trying to say in my presentation, platform to business regulation already provides for a horizontal set of rules, in particular when it comes to transparency and fair contractual conditions, and there is no doubt about that. The point is that following, well, already at the time of the adoption of the platform to business regulation, but then in the period during the adoption process and later on, I mean, you have seen ample evidence through the antitrust enforcement, not just in the EU, but wider, through a number of reports and studies which have been prepared, but also, let's say more generally the calls from policymakers, that there are issues in the platform ecosystem which go beyond, just simple transparency and fair contractual conditions, where you see that there are certain providers, certain large digital platforms that, through their behavior, which is often unfair and, can undermine the contestability of the markets, may lead that many of these markets tip in favor of very small number of market operators, which can then lead to many negative consequences in terms of, both innovation, but also choice for users. So it has been felt that, we cannot really wait for, assessment of, impact of these, let's say, general transparent and fair contractual condition measures, because the problems which we are tackling go far beyond that. It's not only about transparency and fair contractual conditions, because even, if it's transparent that, let's say, service providers use parity clauses, for example, which is essentially what the platform to business regulation obliges them to do. I mean, the experience from the antitrust enforcement in certain sectors shows that, first they are used, and second, they have very negative impact in certain circumstances on the market. So it has been felt that, we need to intervene in those specific circumstances and in that very narrow scope already at this stage. Otherwise, certain solutions may come way too late to tackle the problems which we have. And again, the impact assessment provides a lot of grounds and evidence for that. And you will also see from the developments, not just in the EU, but also across the globe. For example, in the US, you will see end of last year many antitrust enforcement actions by the FTC and DOJ, and now recently all the bill proposals which are very close to what the Commission has proposed with the DMA, which essentially again try to recognize that there are specific problems when it comes to these digital gatekeepers, which need to be tackled, not just through antitrust enforcement or some general transparency and fair contractual provisions, but rather, with very targeted set of measures that will tackle the problem. So, yeah.
Thanks.
Great. So thank you very much. First of all, I think that it's already time to start closing, because we are abusing from the public services that you are so brilliantly providing, Dennis. So first of all, thanks so much for your generosity on sharing with us all your knowledge on this important regulatory package, on which we will be certainly following up. I would also like to thank the audience for the patience, but I think that it's been worth kind of extending the session to kind of cover all the issues that have been posed today. And in any case, as part of the activities of the Digital Economy Group of our European network of firms, we will certainly keep up following this important development, and we'll certainly be organizing in the next month new events connected with such development. So thank you very much. Enjoy very much your summer break if you are close to this, and in any case, we stay in touch. Thank you and have a great day. Bye-bye.
Thank you.